So the first point is the Building Safety Act 2022 gained some new legs. Specifically, 3 sets of regulations were published in August and came into force on the 1st of October. These regulations set out in more detail the high-risk building regime, how it works from a practical perspective, what you need to send to the building safety regulator, that sort of thing. And as I say, it's now in force as well. In addition, there were transitional provisions which were put in place for projects which had started to begin prior to 1st of October, which will continue until April next year. Another key case which has come in, which impacts the way that payment provisions are drafted in contracts. In Lidl Great Britain Limited and Closed Circuit Cooling Limited, the judge held that when you are drafting for a final date for payment, the final date for payment must be fixed by reference to a number of days after the due date, and not also by reference to when a VAT invoice is received. Doug?
Yep, in a second judgment, in fact, arising from the dispute between Lidl and Closed Circuit Cooling, the court revisited the principle that a paying party, in default of its obligation to pay the notified sum, can't raise an adjudication on the true value of the works until it's paid the notified sum. The court found here that what's meant by a true value adjudication is an adjudication on the value of anything which the paying party could have dealt with in a timely payment or pay less notice, which would include cross claims by the paying party and adjudications on just specific items within the account. There have been a couple of other interesting cases on adjudication. One is Crystal versus DMSL, in which the court looked at the types of works which count as construction operations for the purposes of the Construction Act 1996, and another case looking at what counts as construction operations in England in the context of works carried out to the seabed or in a tidal river. That case is Van El versus Kindvor Moorlift. Outside of the construction sphere, we've seen a pretty interesting judgment from the Supreme Court on the circumstances in which commencement of the statutory limitation period might be postponed where the defendant has concealed relevant facts from the claimant. That's Canada Square versus Potter, and also a decision of the Court of Appeal in which it decided that the court has the power to order parties to take part in alternative dispute resolution procedures. So neither of those cases is about construction, but they're both likely to impact construction claims. And Jamie, what about in terms of the things which may be coming in 2024?
So on the transactional side, I think the 2 things to particularly look out for are, first of all, in likely spring next year, we're expecting new editions of the JCT contracts. The JCT 2024 will include a target cost contract and some changes to the existing forms, including modernising and streamlining major legislative updates, particularly around Building Safety Act and the Corporate Insolvency and Governance Act, and also future-proofing. In addition, the Procurement Act 2023, which gained royal assent in October, will start to come into force, likely in October 2024, and with it there'll be some fairly significant changes to how particularly government projects and construction projects are procured. What about on the dispute side, Doug?
So there's a likelihood that we'll see the Supreme Court's decision in Abbey versus Simply, which hopefully will later rest the question of whether a collateral warranty is a construction contract for the purposes of the Construction Act 1996. And we could also expect to see the progress of the arbitration bill through Parliament, and that bill proposes some important changes to the Arbitration Act 1996. I think those are the main points. So thanks everybody very much, and we look forward to seeing you in 2024.